Let me move on to Amendments 5 and 6. Amendments 5 and 6 deal with legislative redistricting. They're essentially the same amendment, it's just one of them will apply to state legislative districts for House and Senate, and the other one would apply to congressional districts. Every state goes about its redistricting in a different way. After every census that we have a census every 10 years, each state will come up with a plan to redistrict, to renew its districts. In the state of Florida, our legislature has a great deal of discretion. The legislature is the one that does the redistricting. Governor in Florida does not have a veto over the state, the Senate, and the House, although on the congressional stuff, the governor does have a veto. With respect to what the legislature has to do when it draws up the districts, it needs to ensure that there are roughly the same amount of people in each district, one person, one vote. The legislature also needs to make sure it doesn't run afoul of, the districts have to be contiguous, and the legislature has to not run afoul of the Voting Rights Act of 1965. Beyond that, the legislature can do whatever it wants in terms of drawing up these districts. So there's lots of concern. I think most of us are familiar with the term gerrymandering, or the idea that legislators or politicians would rather, like, they choose their voters as opposed to the other way around. It's happened. It's widespread. Regardless of which state you're in, whether it's controlled by Democrats or Republicans, the name of the game is you try to keep the party in power, and you try to protect some of the incumbents. I think what you need to understand in the state of Florida is every time you go through this process, our Supreme Court does something that's called a declaratory judgment. The Attorney General, within 30 days of the plan being put forth or passed by the legislature, has to look at it and see whether it hits any tripwires in either the federal or the state constitution. Last round, in 2002 and 3, our Supreme Court was very clear in that its scope in terms of reviewing what the legislature does is very, very narrow. And a number of arguments were put forth, challenges on a variety of different issues, again, on contiguity, on one person, one vote, on the Voting Rights Act, on gerrymandering under the Equal Protection Clause of the Constitution. But very interestingly, there was an argument that was put forth that it challenged what the legislature did and said, you didn't pay attention to compactness and existing political boundaries. And the Supreme Court dismissed it out of hand and said there's nothing in our Constitution, the state Constitution, that says you have to pay attention to those things. So in large part, this effort is a reaction to that 2003 Supreme Court decision. The operative language in the amendment says it can't favor or disfavor, and then it runs through the Voting Rights Act and protecting that, and then it says, to the extent possibly, pay attention to compactness and existing political boundaries. The opposition to Amendments 5 and 6 point out a couple of things. First, on that favor or disfavor part of the clause, by definition, if you change the status quo, I think you're kind of favoring or disfavoring somebody. So they put forth the argument that this is impossible to implement, and also on some of the more contorted gerrymandered districts that we have in the state, some of them are special election districts that actually have a high concentration of minority voters. And under the Voting Rights Act, there are some very strong protections in terms of having representation in the government body that's in rough accordance to the population, minority populations. And so there's concerns that if you were to simply focus on compactness and existing political boundaries and you broke up some of those districts, you might actually lower the percentage of minorities that were in the legislature or in Congress, and that would violate the Voting Rights Act. So those are a couple of the arguments against it. The proponents come back and say, given the software that we have, it would be relatively easy to do a little less gerrymandering and make things a little bit more, compact and pay attention to the existing political boundaries without running afoul of the Voting Rights Act. You're hearing that both sides again debating. You can't implement it, and you're gonna have a problem, and the other side says no problem to implement it.